There are now a group of women of an indeterminate size who no longer have access to free contraceptive coverage simply because of some religious views that are held not by them necessarily, but by their bosses. We disagree, and the constitutional lawyer in the Oval Office disagrees with that conclusion from the court. And that's why we, primarily because he's concerned about the impact that it could have on the health of those women.
All right, folks, there's your White House take on the Supreme Court decision today. And here we go again. Joining us now, I'm very happy to say, is Adèle Keim, legal counsel for the Becket Fund and attorney for the Green family in the Hobby Lobby case. Congratulations, Adèle.
Hey, thanks for the congrats. We're thrilled. This is a great day for religious liberty.
It really is, and what a landmark case to be involved in. So congratulations to you personally as well, and the Becket Fund, which has done such great work. You know, this argument, I don't know if you were on the whole time. We just played the president's spokesman. Again, you know, the president's concerned for the health of these women. I mean, you know, I had an attorney on in the first segment, and this is how crazy it gets, and this is what they'd have to be talking about to be concerned for the health of these women. She compared it to a blood transfusion. What if another religion doesn't believe in blood transfusions and they own a business? Are they not going to get? I said, you're comparing blood transfusions to an abortion pill or a contraceptive pill? I can't even begin to say how shallow the argument is that these poor women now will not have access to these pills, as if they can't walk to the drugstore and get them.
You know, absolutely. One of the government's main arguments in this case is that they have been the defenders of the Greens' employees. But I want to tell you, the government marched up to the Supreme Court and said that the Greens should just drop all health insurance for all of its employees and not pay them a dime more in compensation, and that would be a perfectly legal, acceptable alternative for the Greens. Do you know what the Greens said to that? They said, no way. We would never drop our employees from health insurance without compensating them more. And, you know, they fought all the way to the Supreme Court to avoid dropping them at all because why? Because the Greens know they have single moms on their plans. They have parents with sick kids. They have employees battling cancer. They didn't want to leave those people out in the cold. Now, listen, the government in the Greens and the Hans case, let's not get overheated. They're only talking about a handful of emergency contraceptives, those very few contraceptives that may act by destroying a human embryo. We know this. The FDA admits it. The government doesn't dispute that the drugs can kill a newly created human life. The Greens and the Hans didn't want to supply those drugs, and the Supreme Court said they didn't have to. In another case about blood transfusions or these other wild hypotheticals that the other side has been reaching, the government might be able to show that it had some kind of compelling interest, but we know they don't have a compelling interest here because they've already exempted plans covering almost 100 million Americans from the contraceptive mandate to keep the president's political promise that you can keep the health plan you have. What the justices did today was right, and it was right down the line. They did exactly what they needed to do. They applied the law carefully, narrowly, in a balanced way. That's how religious liberty works in this country.
But Adèle,
this is a great day.
I'm fascinated by what you just said because I got to confess I wasn't aware of that. So the government said that if a way around this, or they argued this in the case, you're telling me in the case, they said that it would be perfectly legal for Hobby Lobby to drop all health insurance and not compensate the employees for then having to go out and buy their own or pay for their full amount of their own policy. And that was an alternative that the government suggested. Is that what you're saying?
Solicitor General Donald Verrilli stood before the 9 justices of the Supreme Court and said the Greens are not burdened because they could just drop all health insurance and pay a fine.
So that kind of puts a hole in their little argument that, you know, what would these poor women do when they were willing to sacrifice all health insurance for all poor women and men?
It was tough to sit quietly and listen to that argument be made.
Wow, that's amazing. All right, so and let me give you another one here, and educate me here. There is no provision for, and again, this was brought up by the same female attorney that I had on in the previous hour. You know, there's no provision. I brought this up in response to her. There's no provision for condom coverage for men or birth control for men. I understand women have the babies, but men use birth control. Men buy condoms. And she said, well, men have the option of a covered vasectomy. And I said, you're comparing a vasectomy? I said, if you want to go down that avenue, I would assume a hysterectomy is covered for women, but that's a ridiculous analogy.
Listen, it doesn't, it misses the point completely because the Hans and the Greens already cover the pill and other kinds of contraceptives that are used by the overwhelming majority of women in America. Look, let's get back to the reality of this case. In this case, the government is trying to ram its contraceptive mandate down the throats of the Greens and the Hans. The Supreme Court stood up and said, no, you can't do that. But you know something? The government has not stood down from its war on the nuns. It continues to insist that the Little Sisters of the Poor and Mother Angelica and her Catholic TV station, Eternal Word, and the bishops and all kinds of other people, the charities they run, have to turn their health plans into a conduit for the government's contraceptive delivery system. I think the handwriting's on the wall for that position. Look, the court said today that when the government has a less restrictive alternative, it has to use it. And the court said paying for these drugs itself, the government has a less restrictive alternative if it just provides these drugs itself. You know what? The government has offered a half-baked shell game of an accommodation for religious nonprofits, but it has insisted in those cases that it should not have to pay for these contraceptives itself. It should still be able to commandeer somebody else's health plan and make them or their insurance company pay for it. I think the writing's on the wall with this decision for the government's argument that it can just force Americans, whether they're companies, for-profits, or nonprofits, to do its bidding when they have a religious objection. The court said today, when the government can deliver the drugs, the government has to deliver the drugs.
Yeah, I mean, that is absolutely, I think, absolutely true. I think if anybody had a bet, and they had a bet that which case would go the government's way, and if one was going to go the government's way and one was going to go the way of the plaintiff, certainly I think the Little Sisters of the Poor and people who fit that category had a better chance of winning. But now that you guys won, I don't see how they could not win. Right?
We certainly hope the Supreme Court and the other courts of appeals see it your way.
Anyway, yeah. Now let me ask you another question about paying, because the court mentioned something that, as you just alluded to, but I'm a little confused, and I want to get this straight too. That the government would pay for the pill. So does that mean now that we're all going to be paying for these abortion pills, or these pills that Hobby Lobby did not want to provide for, or is Hobby Lobby just, do these women have to go get it on their own? How's that going to work?
Well, the government might have to. So let's step back for a minute.
Yeah.
Look, for decades, the government has had a program called Title IX, where they spend last year, I think it was roughly $300 million of federal tax money to provide contraceptives for free or at no cost to American women. They do this through Planned Parenthood clinics. They do this through county health clinics across the country. They have a whole network of distributors who are their voluntary partners who say, yes, government, I opt in. You will give me money. I will make sure these drugs get out to the women who need them. That's the kind of program that the plaintiffs in all of these cases, for-profit and non-profit, have pointed to and said, look, the government has other ways of getting these drugs and devices out to American women. It can just add more funds to that program or just direct women to that program. So that's the kind of alternative that's less restrictive in these cases. What they can't do is coerce religious people against their conscience. When they have a clearly available alternative, like the existing Title IX program or some kind of new government program they might want to create, they can't force religious objectors. They can't to knuckle under. So that's what the court.
Gotcha.
I think that's the writing on the wall. The court, to be clear, the court was careful to say, look, we're not commenting on the not-for-profit cases; those aren't before us. So, but I think the writing's on the wall.
One more for you. You've been very generous with your time, Adele, and that is the bakeries, the photography people who have lost their jobs or who have been forced to now, they've been fined or with the threat of closing down, that they have to bake a cake for a gay wedding or take pictures of a gay wedding or a gay ceremony. How does this case apply to those kinds of cases?
Sure. So this case was narrow. It was balanced. And you know what? Under our law, all religious liberty cases are like that. This case said, look, just because the government's position in this case was pretty extreme, once you incorporate, you wave goodbye to your constitutional rights of free exercise of religion. That was the government's position in this case. I'm very, very pleased to say that 5 justices of the Supreme Court rejected that argument and said, no, just because you incorporate, just because you own a family business, what they used was closely held business was the term they used.
Right.
It doesn't mean that you lose your constitutional right to exercise your religion. So the same will be true of any other business owner. But in all religious liberty cases, religious liberty is a balanced right. So the government can always come into court and say, look, we have a compelling interest, for example, in eradicating racial discrimination, and so therefore we can't make an exception for this or that business owner. That's just the problem is, for the contraceptive mandate cases, they couldn't meet that because of the huge exemption assumptions we've already talked about. So it was a careful, it was a balanced decision, and it was a decision that pushed back. And by the way, on that point, that threshold issue of whether a for-profit company could ever exercise religion, you had 5 justices saying they can, 2 justices saying they can't, and 2 justices, Breyer and Kagan, definitely on the liberal wing of the court, saying, look, we take no position on that. We're not going to weigh in. And they've quite clearly, I think, had in view the kosher butcher and the Torah publisher and the halal grocer, who everybody can kind of agree. Wow, we see that these business owners are exercising religion.
There you go.
So there you go.
Yeah, no, very good. Adèle, you explained it all so perfectly. I thank you, and again, congratulations.
Thanks so much. You have a great day.
You too, Adèle Keim, ladies and gentlemen. All right, when we come back, it's Give Me 5, and you're not going to want to miss it. I promise you that. On the Steve Malzberg Show on Newsmax Television.